All right. Good afternoon, everyone, and welcome to the CLE on understanding the legal weapons landlords and tenants have in enforcing, terminating commercial leases and the secrets of how to negotiate the best abatement deferment so both landlord and tenant are happy, by Adam Leitman Bailey, PC, and sponsored by AmTrust Title. My name is Jeanette Rahman, Director of Agency Services at AmTrust, and I will be your MC for today's presentation. I'd like to go over some house rules, some basic house rules. All participants will be muted to ward off background noise and feed. If you'd like to ask a question or make a comment, please do so in the chat section. This CLE is for 1 credit and will be provided by National Academy of Continuing Legal Education, an accredited New York State and New Jersey CLE provider. This program will provide professional practice credits for experienced and newly admitted attorneys and is being recorded. No credit shall be awarded for attending a portion of the program. In order to receive credit, we have circulated an attorney affirmation and evaluation form. If you need a copy, please enter a comment and we will forward same. A code will be provided during and at the end of our program. Please enter the code on the affirmation and then send the fully completed forms to Anuska Amparo at amtrustgroup.com. Without further ado, I'd like to introduce our speaker, Adam Leitman Bailey, founder, partner of Adam Leitman Bailey, PC. Adam?
Thank you so much for having me. Thank you, AmTrust, for your confidence. It's been a pleasure working with you for so many years. And I'm honored to give this lecture today. I'm honored to be a real estate attorney during these historic times when we are, as real estate attorneys, needed more than ever before. Our economy is falling apart. Our city and state are bankrupt. Our government is in crisis. Our people are in crisis. Our civil rights are threatened. Our government is threatened. Our constitutional laws are being thrown out the window. And businesses have never been threatened like this before. And normally when this happens in a society, it usually means when they close courts and credit shuts down and the system of government and there's protests, it usually means the dictator's coming. But I'm hoping not in this case. But let's see what we can do today to try to help what really makes America go and how the United States started with the Dutch in the 1600s, which is business. First of all, anybody with a mortgage, any commercial landlord with a mortgage cannot do anything unless they read their mortgage documents. You cannot go ahead and start a case. You cannot go make a deal. You cannot do a lease modification unless the lender gives you permission. This paragraph that's in front of you right here is standard throughout the industry. And it's normal. And it says, without permission from the lender, you cannot go ahead and start a case. You cannot go ahead and make a deal. You cannot go ahead and do a lease modification, sign a new lease, give a rent abatement, etc. Please don't go ahead and work without the lender's permission. Now, a lot of the lenders are ignoring your request right now. Be aggressive, go after it. At the same time, what I'm seeing and what I'm experiencing is that the lenders' slowness have been gotten away of deals to be made and the ability of courts, the few chances we've had to get into court when there were openings, we missed some chances on it. So we really had to pay the price as a result of that. Okay. That's just tip number one on how we get through this. Okay, let's go through the commercial landlord-tenant pandemic negotiation. Okay, we have the negotiation. We have the lender. We have the landlord, and we have the commercial tenant. The negotiation works out. The lease modification is done. What is the commercial tenant looking for? They're looking for, speak louder. One viewer cannot hear you. Okay, I'm speaking louder. Is that better? Let me know. The commercial tenant wants a deferment, they want free rent, or they want an abatement. This is one of the games I call it being played. Now, yes, of course, the commercial tenant, the number one thing they would like is free rent. And that may be an option. Another thing they'd like is to pay their rent later. That's another option. Another one of the games or tricks or things that are going on is a landlord may say, okay, I'll give you a rent abatement now. I'll give you some free rent now, but why don't we tack on the rent, to later in the lease, but let's extend your lease. That's another a tactic that a lot of commercial landlords are doing that a lot of other landlords don't know that's going on. And how do we judge that? Well, we'll get into that in a second. But let's go through something that a lot of commercial landlords are not doing. First thing you're doing as soon as a commercial tenant's not paying their rent is take the security deposit. One of the worst things that I see in bankruptcy, there's a lot of bankruptcies going on, is when the security deposit becomes antecedent to the bankruptcy debt, meaning that for some reason the commercial tenant did not pay their rent and the security deposit is being fought over in bankruptcy court. No. In almost every commercial lease, the security deposit, if you do not pay it, becomes the property of the landlord if the landlord takes it and draws down on it. In 1 out of every 100 leases as a notice provision, almost none. So as a commercial landlord, please take the security deposit. Once you take the security deposit, then you send a notice of replenishment, because the landlord in every commercial lease, even the REBNY form, the landlord is required for replenishing the security after the landlord takes it. And then if the tenant does not replenish the security, then you can, if you're allowed to, because this is the first time in my lifetime that the government is allowed to actually close down the courts, which is, that only happens in South American dictatorships or in World War II and not, in Germany. But that's besides the point. I don't want to get too political today, although we're forced to. Okay. So you take the security deposit or the letter of credit, you draw down on it. That is free money. Now, let's go back into history and see how much this helped. It's March. If in April and the rent is due, you didn't have the money to pay the rent because it happened at the end of March, then you had bigger problems than COVID and the pandemic going on. So obviously you should have been able to pay more. You should be able to pay, tenant should be able to pay April's rent. So we're really not talking about April, we're talking about May. So May is the first month you may have had any problems. Now we're talking about, okay, April, you're having a problem. Okay, we'll take you to security for April. Now we're in May. Now May, we're talking about the PPP loans. So really, or don't we have any reserves, or don't we have any savings? So isn't that April? So really in June or July. So that's where this gets interesting. So how do we know what the tenant's thinking? Or is the tenant just reading a newspaper saying everyone's getting free rent, so I should get free rent also? So here's where the negotiation goes. So how do we really find out what the tenant's going on? And this is a document that, if you own a lot of buildings or you're in the game or we represent you or someone represents you, then you know about the pre-negotiation agreement. What is a pre-negotiation agreement? And this is an actual pre-negotiation agreement. It starts out and it says, "Dear tenant, landlord has received tenant's request for a potential restructuring of the terms of the lease in connection with COVID-19. Landlord may be willing to enter into discussions with tenant concerning the lease discussions. If tenant executes a copy of this letter agreement to confirm the understanding of the parties with respect to such discussions and provide landlord with certain information and documentation as more, and it goes on. What's going on here? The purpose, this is the landlord thinking. I'm doing landlord, tenant, and lender thinking at all times here. And if you're not sure, ask me about it. Okay. Number one, the landlord wants to know in his pre-negotiation letter, the purpose of it, how badly does the commercial tenant need the loan? In the pre-negotiation letter, we're asking for all the tenant's assets and proof of their assets. Number two, we want to learn where the tenant keeps their money. If something goes wrong, it's nice to know where the tenant and the tenant's guarantor, if there is one, where they're hiding their money or where their money is. So in case we have to go after it, we know where to find it. Number three, is the tenant getting any benefits? How much did they get in a PPP loan? We do know that at least 20% of the PPP loan, for it to go from being a loan to a grant, needs to be paid to the landlord. So if the money is not, if 25% of the rent is not being paid to the landlord, then it's going to stay as a loan. So we know we got money coming into the landlord. So there's no excuse for that. So all this is being filled out in this big document. And this document, when it's filled out, allows the landlord to figure out, okay, this is good. This lets us know what's going on. And it also lets us know, hey, the tenant's in really bad shape. They really need an abatement. They really can't pay any rent for the summer or, through the summer. We're going to have to give them a rent abatement, defer a lot of money. And, it really helps the tenant. It really helps the landlord. And it really helps everybody come to the table so they understand each other. Because it doesn't make any, when I hear the negotiations, when they don't have a pre-negotiation letter, you're a liar, you're lying. Well, but it doesn't make any sense. These are business people. And yes, we can't help, we didn't cause COVID-19. And it's not our fault that our government could not be worse on the federal government, state government, city government. It's not our fault that it could not be any, well, partially, you guys voted for some of these people, but it cannot be any worse that they're acting like this. And the unconstitutional laws they're passing is, that's not we can't control that right now. But what we can do is we could act maturely and get documents to decide, what's the best. Because if we have a good tenant, we want to keep them. And if you want to stay in the space long-term, because this is not going to last forever, then we actually want to stay in the space. So there's good and bad going on here. So we really want to make this work. Now, here's what you want in your pre-negotiation letter. The first thing we do is we have the tenant waive any defenses concerning COVID-19 and anything that they could bring concerning this letter and the defenses they'd have if they sued us right now concerning payment of rent. Number two, we want to make sure it's confidential. For some reason, some of the, I don't know if they call it newspapers, but they'll print some of them seem like they'll print anything that has the word real estate and a famous company on it. So we make it confidential. The listing of assets and very important, the proof of assets. We want to make sure what they're saying in the pre-negotiation letter is true. And absolutely, we want the pre-negotiation, we want the PPP loan stats. We want to know every dime they got because we know we're getting at least 25% and we know they could pay up to 40%. And that's the only way they're getting the grant if they pay at least 25. And of course we like the 40%. We want to know about all bank accounts because for example, we're dealing with one commercial tenant that's saying it can't pay its rent, but then we got the pre-negotiation letter and they're being backed by a major fund and the fund has tons of money in it. So it made the negotiation a bit more interesting. Unemployment benefits. You think that's a crazy thing, but so some of these commercial tenants got unemployment benefits. And look, some of these spaces are large and very big and some are not. But we want to know where every dollar is coming from. Now, you get this. Now you're negotiating. Is there an average negotiation? I mean, what are the negotiations doing? I would say the average is a third free rent, a third deferred, and a third abated free rent, a third deferred, and a third paying out over time. I mean, that is, let's say, the average. Then you have no payments over the summer. They start paying in October. Then you have the tenant asking for, well, we don't want to pay through January. Well, the landlord's view on that is, or my view on that is, well, how do we know what it's going to be like in October or November? We don't know that yet. So it's, there is no average, but it's kind of coming to another thing that's going on is, why don't we look at your profits? Let's look at, some people are doing it month by month. Let's see how you're doing this month. Let's look at your profits and we'll go month by month. Others are saying, we're not making any deal right now. Pay what you can. We'll look at it for the summer because we believe we're in phase 3 right now. We just started phase 3, whatever that exactly means, because they say phase 3, but then they're not allowing you to open up your restaurants. So, but we're in phase 3, so let's see what that means. So there's a wait and see attitude. But the problem that's going on here is that the landlords need to pay their mortgages. And so do you really want to get into a lease modification? Here's the first line of lease modification prepared by Tom First, attorney at our office, who I believe is listening in. I'm checking for questions already. Do you really want to get into a formal lease amendment for a term when you really don't know what's going on? So a lot of landlords did so in April or May for the summer, and that's worked out fine because, it made deals. But then, like, for example, I got an email yesterday from they make croissants and coffee and bakery items. And they said, listen, the deal you just entered into for the summer, we can't pay. So, it's tough out there. And there's no exact answer. But once you come to terms, you do a modification of the lease. Or if you want to get more crafty, you would do a 2-attorney stipulation of settlement to be filed into court, because that skips the step of a lease amendment. It actually gets you right to court, where you would add a warrant to it and a judgment. And if the tenant defaults, then you're already in front of a judge, and you'll skip that part of the long wait you're going to have, because the courts have opened, housing court has opened, or civil court commercial part is opened. They said, we're open, but we're closed. Meaning, you can't buy an index number. You have to buy it through NYSIF or mail. Mail would take months, and NYSIF for civil court is not working yet. So our office is going to state Supreme Court and are starting our cases there. That is going smoothly so far. We're starting our cases in state Supreme Court. So rather than a lease modification like many people are doing, and we're doing those also, you may want to skip that and go right to a 2-attorney stipulation as if you're in housing court. And I would also start a housing court case and tell your friendly adversary, your friendly tenant, hi, we need to start this just as a formality because housing court's so backed up. We may not be actually be able to get a court date for 6 months. So we're going to start this just so we could get in line. And that is actually my better advice for a landlord. And I think a tenant would understand. Now, the lender, the problem, the biggest problem right now is the commercial landlords. The landlords are going to the lender saying, look, we can't pay our mortgages. The commercial tenants are not paying their rent. we can't afford to pay you. And full disclosure, I represent most of the lenders in New York. And by saying most, I'm not exaggerating that. Our firm represents most. So I have to be very careful what I say. And unfortunately, I'm not good at that. But I can continue. So you contact the lender for the negotiation. The lender sends you the toughest pre-negotiation letter you've ever seen in your life. In fact, we borrow from it. And then you ask for an abatement and deferment, and they say, these very sophisticated. I'm getting questions. Okay, these very sophisticated words. No, lenders are not giving abatements or deferments or giving you a break. The only ones that are, and remember, we're representing over 10,000 buildings, more. It's much more than that, but I don't know the exact number. I'm guessing. This loss of voice is from 14 to 16 hours a day or 12 hours a day on the phone, and they're saying no, unless you have that, unless it's a small bank and you're one of the biggest customers, or you're a large bank and you're one of their biggest customers, or you've been with them a very long time. Or the third way in is when you get your governmental representative to call them, and that seems to be the third way to get their attention in their ear. That being said, there's no negotiations going on. So the London negotiation is not going well. Now, however, if you're dealing with a private lender, and I'm not going to name names, they're talking to you, everybody's speaking, but they may be more apt to listen. They're still not giving you an abatement or deferment, but they may be more apt to listen, and they're actually getting more into the games, more as in, oh, I know the building, I know that, why don't you try this, why don't you try that? And their attorneys are getting on the phone, and they're telling me, well, Adam, I thought you're not allowed to serve notices yet, or you can't start a case. What's going on? So at least I'm not getting someone from, I got to pick a state that they're actually not in, which is very hard, from North Dakota. I hope I got that right. From North Dakota. And so I'm not getting a North Dakota attorney for the private lenders. I'm getting someone from New York. And then I'm explaining to them the latest memo that came out, or executive order and a law. And at least I get to speak to someone to get permission to get the things moving. Okay, let's handle the question that just came in. What about landlords getting mortgage relief? What liability fall exclusively? So there's no, the protesting. It's really weird. Can we do that? Can we just get as a joke or for fun, get all the landlords together to do a protest? And how about the lenders? Let's get the lenders out there to do a protest also. Why would liability fall exclusively? And it wasn't, the question didn't go through. But no, landlords are not getting any mortgage relief that I know of. There is a bill going through right now that the governor's best friend, who I'm not going to name, but you could probably guess if you know the inside of politics, asked me to jump on and make noise. There's a bill going through Albany really quickly because you're going to see very soon that the moratorium for mortgages is about to end on August 19th to 20th. And there's a bill that's trying to stop you from prosecuting mortgages, stop mortgage foreclosures from going through. If the bill passes, we have a real problem as a foreclosure firm. So please call your local state senator and state assemblyman and the governors to make sure that bill doesn't go through. Okay, that's the political plug. Okay, now, if you're a landlord and now you have your pre-negotiation letter, what else are you looking at? And this is good for the commercial tenants to know also. What are you looking at before you give out that deferment? And this is the exact conversation we have. And here's are the tips and the secrets and the negotiations that I, in my clickbait title of this lecture. The length of time left in the lease. Now, what is the worst thing that can happen if you have 9 years left in the lease or 19 years left in the lease for a landlord? And the answer is losing you. If you're a good tenant with that looks like it's got a good business that's going to make it, we don't want to lose you. So we're going to do whatever we can. I'm speaking as far as the landlord. We're going to do whatever we can to keep you. Now, at the same time, we need to pay we need to make sure we pay the lender. So the deal we're making there is pay the expenses. I got to pay this lender. So I need your PPP loan as much as we can get. I need the utilities. I need to pay this mortgage payment. And a lot of the landlords are opening up their books saying, here's the bank, here's what they're asking for. I got to be able to pay this. But they're making deals you wouldn't believe. It's like, hey, we're partners in this. You want me to be your landlord? I need you to pay some money. But we'll make a deal with you because you got 19 years left in your lease and we want to keep you. And we're very aware, look at the next one. We're very aware of that good guy guarantee that you could send in, that you could cancel the lease in 90 days notice as long as you paid your rent on time. So if you're a tenant and you have a good guy guarantee, that is your get out of jail free card. As long as you paid your rent on time, and be careful that paragraph that you remember. There's two things depending on how good your transactional attorney was. And a good guy guarantee, there's two things. Number one, there's some that only require that you paid your rent on time, and there's others that require that, number one, you paid your rent on time, but you paid your rent on time, but you also were in compliance with all provisions in the lease. And that's the one where you come to a law firm like Schmigegi, and they may find something. So be careful of that. So there's a guarantee. So there's two things. That's the good guy guarantee I just discussed, where it lets you out on that. And then there's a guarantee where the landlords celebrate drinking champagne because they have a guarantee. They ran an asset search. The guarantor has a lot of money, and they know this tenant's not going anywhere. And they're thinking, I'm not making any deal with this tenant because I realize that I'm getting paid after this guarantor, and I'm aware of the Holy Properties versus Kenneth Cole case, which Jeffrey Metz won in 1995. I'm plugging our partner, selfless plug, Jeffrey Metz of our firm, because you do not have to mitigate damages in New York for commercial. You have to, as of June 2019, need to do so for residential, but you do not have to do so for commercial. Therefore, if the tenant leaves, you could close up and not have to rent it to anybody else. However, if a tenant does leave and you can't go after the guarantor, or they hide their assets really well, do you really want to go into this new market? Or let's say the guarantor goes into bankruptcy. Do you really want to go into this new market where unemployment in New York City right now is 27.5%? During the Great Depression in the 1930s, the unemployment rate was never that high. Think about what we're walking into. And before COVID, our state budget was already going into bankruptcy. And the city budget, forget it. I mean, Mayor Bloomberg had a surplus of billions of dollars. I don't know how de Blasio spent that much money to put us in such a deficit, but he did. So unless the federal government bails us out, I don't know how who they tax first. The good news about that is they're going to be forced to incentivize real estate. They're going to be forced to incentivize you real estate people to and there's some big names that listening right now, they're going to be enforced to incentivize you real estate people to build. And they're going to have to make it where they're going to hopefully get rid of rent regulation and make programs where you're forced to build and make money so you could pay taxes. How viable is the tenant and the new world performance of tenant prior to March? Number one, how were you before the COVID? Did you pay rent on time? Did you complain? What kind of human being are you? And then, what kind of business are you? If you are, if you're in a business of having 1 million people in an open space, renting offices temporarily, I don't know how many people are going to be risking that right now. Maybe that's not the best business to bet on, but that's something the commercial landlord has to, I mean, what do I know? I mean, I'm just a small time attorney, but that's, looking at the business is something the landlord's doing right now. Next, the rent paid and the rent the landlord would get in a new market. That's what I just said before, and it's scary. So the landlords do not want to have new tenants if they don't have to. At the same time, right now, unless there's a self-help clause in the lease, and by the way, read your leases. If you have a valid self-help clause, and there's many articles on self-help, at least 10 on my website, please read them, because if you have self-help in your leases, you don't have to go to court. You can use them. But if you don't have that and you have to go to court right now, and court's broken, and even in state Supreme Court, it's going to go slow, you may want to have the tenant with you rather than the tenant that you have to go get, especially since it may take forever to evict them. The chances the tenant will go into bankruptcy. That is a really good reason to negotiate with the tenant. Because if the tenant goes into bankruptcy, they may be in there a long time before the bankruptcy is over. And number two, right now it's very hard to show a space. And once you're in bankruptcy, it's going to be a long time before you get them out. So these are reasons to negotiate. Let me check for questions. And we're doing good. Okay. Okay, this is a lease modification after negotiation. It's the usual provisions, very standard. I'm not going to spend time on it because we have a lot to do. Okay, as attorneys, there's no commercial lending market by the traditional banks. There's no credit. The few deals you're seeing are coming from the private banks, the private lending world, and those deals are happening, but they're happening. There's few and in between. The deals you're seeing are deals that happened pre-COVID. They had to be renegotiated for the discount, and then they're happening now. There are deals being negotiated and things talking about they will be coming out, but they're not coming from the traditional banks, and that's a whole different lecture on why. The New York City Guarantee Law. On May 27th, the City Council passed a law, and it stated that from March 7th, 2020 through September 30th, 2020, landlords may never enforce personal guarantees of certain commercial tenants. Under the law, the guarantor is again liable for any rent or other charge defaults that arose either before or after the COVID period. The economic defaults from which the guarantors are relieved of enforcement include utility expenses or taxes owed by the tenant under the lease or rental agreement, or fees and charges relating to routine building maintenance owed by the tenant under the lease or rental agreement. Now, this is why the law is unconstitutional, because the United States Supreme Court, amazingly, in 1933, allowed a Minnesota law that allowed you to pay your mortgage late to be held constitutional by the United States Supreme Court. And it had a 5-factor test. But one thing it said you couldn't do is you could not bar payments permanently. And the reason was is because the contract clause says that the government cannot interfere with private contracts. It's called the contract clause. So, and the other part of this law is that it's very limited. I know that every commercial tenant believes that they're off the hook for guarantors from March to September 30th, but they're not. It's only restaurants and bars banned by the governor's orders from on-premises food service, retail establishments shut down for being non-essential, gambling facilities, gym, fitness centers and classes and movie theaters, and hairdressers and other cosmetic establishments. Everybody else doesn't apply to this. Also, the only guarantors this law protects are actual human beings. If you're an LLC or another business entity, you're not protected. And if the guarantee is a separate document, I'm not so sure you're protected, which that needs to be litigated. Residential doesn't apply. On July 6th, Executive Order 202.48 appeared. It ended other executive orders prohibiting court actions dealing with rent, except to continue for 30 days, stopping commercial evictions and commercial foreclosures. You can send out a notice, but you cannot proceed with a commercial eviction or foreclosure for 30 days. Now, in foreclosure court, in state Supreme Court, and all 5 boroughs, there's no action going on. No auctions are going on. No auctions are going on unless they're out of court. They're outside the court's purview. Motions are not being heard. Motions are not being decided. And we're starting cases in state Supreme Court. We're able to start them. We're able to send out notices, except some of the banks will not allow you to won't start any notices until the I had the slides here, but I don't see them. But they're not doing that until all the moratoriums of the executive orders, which end August 19th, August 20th, are over. So right now, nothing's much is going on. We're starting cases, but they're really not going anywhere. So it's not a good time to be foreclosing since it's just not working. A chart came out in the Wall Street Journal today. Guess which state's leading in defaults in the United States of America for mortgage defaults? You guessed it. It is New York. Okay, let's get to some weapons. Frustration of purpose. Let me see if there's questions. Let me move this over here. Oh, we got some stuff. Hold on. Okay, question. How, if all, do some of these guidelines shift if the agreement is a license agreement instead of a lease? No, the license agreements and so in the license agreement, a true license agreement, you could get out of the license agreement at any time. So that gives you a lot of leverage against the landlord. As far as the guidelines for PPP loans, if you got a PPP loan, you're still going to have the same, it's going to be treated as a lease. As far as negotiating, you're in a much better position for negotiating because you could get out at any time. Let me see if there's any other questions. And I don't see it. Okay, we're getting into some of the weapons here. Okay, there's 3 weapons that can be used in court to win your cases. Okay, we have another question. Does the New York City guarantee law apply to offices, CPA, lawyers, etc.? No. No, but you may be able to use this screen that's up right now. The New York City guarantee law only applies to the 5 slides that I put up. If you want a copy of these slides, if you want the article that I wrote on the guarantee law, if you want any of the articles I've written, I am on LinkedIn. My email address is public. I will be happy to give you anything that we have. We are lawyers. We share. We're very giving, and we're happy to help you in any way we can, as long as we're not against you on that particular case. And that is how our law firm works. If you haven't heard of us. Frustration of purpose. This is the weapon that you should be using most in your cases if you are a commercial tenant. If you're a landlord, this is the one you should be most afraid of. And in the history of America, this is the best time to be using this because it hasn't really worked in the past, mostly because it really hasn't been recognized until World War II. Started in World War I, but they used other names for it, like constructive eviction. World War II, it picked up steam, but now I think it's ready. But let's go over why it's so great, what it's working, or so great is maybe an exaggeration, but why it should be working, and what we're doing here. Okay, let's go slow. Question. Okay, the purpose that is frustrated was a principal purpose in making the contract, such that without it, the transaction would make little sense. These are the elements. Number 2, the frustration of purpose must be substantial. Number 3, the non-occurrence of the frustrating event was a basic assumption on which the contract was made, and whether the frustrating event was unforeseeable. Now, I put a quote down here. I'm going to read it. Very important. Where, after a contract is made, a party's principal purpose is substantially frustrated without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, his remaining duties to render performance are discharged unless the language or the circumstances indicate contrary. Now, the New York courts apply this narrowly. Generally, New York courts have narrowly construed the frustration of purpose doctrine. And when determining whether to invoke this doctrine, they have considered, the factors we just said. But basically, the New York courts have been against choosing this. They've always tried to get around it. And and if you haven't reached that it was the principal purpose of the contract, that you could not have predicted it was going to happen, and that the frustration of purpose, the event that happened, is substantial, and it was not foreseeable. If you don't hit those, you've got a loser. And courts do not like seeing it. But the facts of this crisis, really fit this mold. This is the one that works, except for one thing. And that is, if you have a 20-year lease or a 10-year lease, and this started at the end of March, so you have April, May, and June, and part of July, but you were allowed to reopen, unless you're a gym or some of the other places that are just taking a beating because they can't reopen because they're not allowed to. But if you're a restaurant that's allowed to keep their kitchen open and feed thousands of people through delivery, or you're able to sell through the internet, there's never been such thing as a temporary frustration of purpose. But maybe it's time to argue that. But let's go over some examples. Let's go over a bunch of examples. Because force majeure Like, let's just get the force majeure to get over with. Force majeure doesn't work because it has to be in a lease. And you have to look at the lease and the four corners of it. Every one of these weapons, you have to look at the lease. And the problem with force majeure, and every time you look at a lease, is it always says that even if you can use it, you still have to pay your rent. So contractual force majeure clauses are clauses excusing non-performance due to circumstances beyond the party's control. New York courts have narrowly defined the scope of force majeure clauses and have only excused performance when they have contemplated a specific event that is claimed to have prevented performance. So if you want to, the main key for the commercial tenants is to get out of rent. New York force majeure clauses do not excuse rent and therefore are not much help during this pandemic. That's my bottom line. Impossibility, the impossibility of performance occurs when an unforeseen event changes things such that the promise or condition no longer can occur. A concert's going to go on. The governor, because of the boyfriend, you have to really be, because of the boyfriend, he doesn't like the boyfriend, shuts down the concert and puts out an executive order. The concert can't go on. Therefore, there's no concert. So the subject of the contract is gone. That's impossibility. The subject, everything's blown up. Impossibility must be produced by an unforeseen event, such as an act of God or by law. So let's say that you were going to have your concert at Jones Beach. A fire took place right where the concert's going to be on that night. That's impossibility. As a result, both parties' duties under the contract are deemed discharged. So that's going to work for many events that happened during COVID. But that's not going to be your regular landlord-tenant situation that we're talking about, or lender-landlord-tenant situation. New York courts construe this doctrine narrowly. They don't like these doctrines. The courts don't like them. But I think they may start liking them now, but only in specific circumstances. New York courts construe this doctrine narrowly and use it to excuse performance only when the destruction of the subject matter of the contract or the means of performance makes performance objectively impossible. We have a question. I could go over impossibility examples, but it's 247. So let's go back to force majeure, because that's where I think we may have some winners. And I like to go into examples of that, but let's go to the question. Before coronavirus, did anyone enter into a lease based on the assumption that a pandemic would occur? Did anyone enter into a lease based on the, I don't know anyone that predict, I don't know. Okay. I don't know, Siri's getting involved. I don't know anyone that I don't know anyone that before December predicted the coronavirus. Now, it wouldn't actually been that crazy, because if you saw what was going on in China, and you knew that the government did not shut down flights from mainland China late February, it wouldn't be that crazy to have predicted that. But I haven't seen it yet. I'm sure we'll see case law on it. Any other questions? Hi, Adam. Great webinar today on commercial leases. You said that there is a true licensing agreement, which I believe is what I'm dealing with. The licensee can get out at any time. I knew the licensor could get out of the contract at any time, but I didn't know the licensee could also. Is that statutory? A true license agreement means that both sides can get out at any time. Otherwise, it's really a lease. And that is the subject of a license agreement. If the person wants to send me a copy, I'd be happy to do it for them. I also have 5 or 6 articles on my website that explain, you just put in the search engine license agreements and you'll see the rules of license agreements. Okay. Okay. So remember, we're starting in 1915 in these examples, which help you understand the history of frustration of purpose cases, which is important, but they really didn't catch on until later. And there weren't commercial leasing cases yet. 2 New York appellate cases, both taking place in 1915, serve as the foundation to the frustration of purpose. In both cases, advertisers who were to pay for advertisements in a yacht race souvenir program were held discharged when the race was canceled because of World War I. Okay, that should do it, right? Where'd it go? And the answer is, and I have it here. The language is boring, but the answer is yes. In 2 of the cases, because the World War I canceled the yacht race, everyone got their money back for this advertisement. Okay, but let's get into more interesting ones. And we'll keep this up. Okay. Appellate Division, First Department, 2004. Crown IT Services versus Koval Osen. Credit Suisse gives these 2 partners an exclusive and then fires them. So their claim was, their whole purpose of their agreement was that they would do computer services for Credit Suisse, and they had an anti-compete clause. So they said, well, there was a frustration of purpose because they got fired by Credit Suisse. The court said, no way, we're not going for that, because although you may make less money, but you could go ahead and get other businesses. So the agreement was not conditioned. By the way, this is very important. The agreement was not conditioned on the Credit Suisse contract. Although they may make less money, they could go somewhere else. So that's important to understand. Rockland Development Associates. These are appellate division cases. 173 AD. If you want sites, I can send these to you. This is 1991. Auto Shop. They had an agreement in the lease that they would not build another auto shop in this 2 building complex. Same thing. They put 2 auto shops. They sued, saying frustration of purpose. The subject of this lease was that you wouldn't put an auto shop next door to me. They lost on frustration of purpose. Lost profits is not enough for frustration of purpose. It's got to be a substantial part of the contract, and lost profits is not enough. You can't look at lost profits. 1991. Next case, 1943. Everything's appellate division. Most of these are First Department. This one I like a lot because it's a lease. And this is interesting because it's a commercial lease, and it's very hard. By the way, good luck finding any case where anybody won through World War II, because it's really very hard. But Robitech Investing Company versus Colonial Beacon Oil, 1943, appellate division, First Department. A lease, gasoline station, War Production Board, substantially suffered financial damages because the War Department limited how much gas they could pump. The court said, nope. You're lying, the court said. You could pump gas. You're restricted. You would make less money, but it didn't frustrate the subject of the lease because you were still allowed to make money on gas. So those are some examples. Now let's go into COVID, okay? You have, and let's get into the elements, okay? Okay. You have, okay, so if you have a gym, let's take the gym. The principal purpose of a gym is to have people there to use it. The government completely shuts you down. You can't use it. You could not predict it was going to happen. The frustrating event is a basic assumption of the contract, which is to use a gym, and it's substantial because no one's allowed in because they ban gyms. I think those facts fit pretty well, but here's my problem: is it substantial when it's only been 3 months of a 20-year lease or a 10-year lease? See, this I don't know. These are going to be cases of first impression. Because before COVID-19, we never really needed a frustration of purpose arguments. There's about 30 cases on, like I've read every case ever on the subject. I've written on these subjects many times. In March, I came out with an article on, what do you call it? Getting ready for the, what do you call it? The world coming to an end type of stuff. So, so the question is 4 months enough to find frustration or purpose a viable weapon? And the answer is, will the court carve out a temporary frustration or purpose? What's going to happen? I think the courts are going to have to make some new law. They're going to have to take frustration or purpose and take it to a new level. I think that for possibility of performance, this is going to be easy for concerts and events or anything that blew up that you just can't use. It's going to fit in there. Force majeure is a complete loser. There was an Illinois case that if you read the lease, you'll understand a little bit of why they did it, where they found force majeure to help the tenant in Illinois, but we don't follow in New York. We don't actually follow other states because we are very egocentric here. But force majeure is not going to help you. Business interruption insurance, and we're going to end on this because we have 3 minutes. Business interruption insurance. Now, business interruption insurance requires that you have a hit. We have a question. And then I'm happy to stay late for questions. We have a couple of questions. Do you expect holdover penalties resulting from a failure or inability to vacate during the pandemic to be enforceable? Yes, I do. I think if you go back, we've reviewed every case from the scarlet fever, the Spanish influenza, smallpox, and it was the appellate division was law and order. And the judges who I speak to daily, because we only practice law in one state, and it's, let me get rid of this. We, hold on. We only practice law in one state, so we only practice law in one state, so we only practice law in one state, so we review every case. So the cases from all of those other pandemics were law and order, and they had no Rahmanis, they had no charity or sympathy for the tenants. Our socialist, communist legislatures may be that, but our judges are not like that. And I didn't give a code. Our code is thank you. Our code is AmTrust title. AmTrust title is our code. Calling code AmTrust title. So I do believe that the courts are going to follow the law. Maybe there'll be some that don't, and the appellate division will catch up. But I really do believe that they're going to. I really do believe that they're going to follow the law. There's more questions. Okay. The with there's more questions. Can the three defenses be used by tenant against landlord claim and landlord defending against lender, or only one? The force majeure claim cannot be used because it still requires you to pay rent. So it's a waste. Don't use it. The other two, the impossibility only works if you have, let's say, let's say that you have a concert planned and it can't go ahead because of the ban. You need the hand fitting the glove. And the slides that you have and the articles I've written will clearly take you through. Oh, there's another article coming out on this lecture on August 19th. So if you want to join our mailing list, we have newsletters by mail and by email now. LinkedIn me or email me and we will get you those. But if you, but it's the gloves got to fit the hand, and frustration of purpose is going to be your best bet. Okay, let me answer these other 11. Hold on. And also the insurance is very important. In many of your insurances, which many of you don't know, and now it's gone. Oh, here you go. Okay, I get more questions to answer. But for business interruption insurance, you need it to hit your premises for it to be, for it to count. Now, my view is if someone brings COVID to your premises and it touches the desk, that is a physical impact, and that's what you need. Number one. Number two, many of you don't know it, but you have the pandemic rider in it, or it's even in the policy. So please have an attorney or yourselves read the policy. Number three, there's a civil authority clause in many policies where it says if the government shuts you down, you qualify as an insured. Please read your policies again, or get them to someone that can, because they're incredible. I love these policies. So you may have these and not know it. And I did a lecture on this, which is on YouTube, on business interruption insurance, and I cover all this. Okay, questions, and then we'll AmTrust title insurance is the code. Okay. Okay, hi, I'm joining late and maybe leaving early. That's a horrible thing. Is this recorded? I believe we're recording it. I don't know if I can send it to you. Email me and I'll find out. Is the PowerPoint available? Yes, we can send you the PowerPoint. Email me or LinkedIn me. Next. I haven't heard codes for the CLE. AmTrust title. Did you forget to give codes? Yes, I did. AmTrust title. Okay. Is there any other questions? If not, for those attorneys out there, I am honored to have the opportunity to be an attorney at this time where we are needed most to do justice, to do good. We need to fight our own court system to open up the courts. We need to fight to do justice for our clients. And for those of you, we have some of the biggest banks that are watching this. Please rise up as business people and help our city come back to life again. And thank you so much for listening. Thank you for being a part, and thank you for being New Yorkers. And may destiny be on your side.